going to ask Marshall Paul from the Defender General's Office to join us. Thank you for being here, Marshall.
Thank you. I'm going to share my screen. I have a brief PowerPoint.
We can.
So, let's see. Does that look right? No, it doesn't look right. It's full screen on my screen. Let's see here. Hold on, I'm going to try resharing here. There we go. Ooh. So thank you. To begin with, I'm Marshall Paul from the Office of the Defender General, Deputy Defender General, and Chief Juvenile Defender. And on H41, this was actually a really interesting bill to start looking at. It resulted in a pretty deep dive into the history of these types of occurrences in Vermont and the current laws that address the handling of corpses, dead persons. And so I divided the bill up into three sections, basically. The green section is what I'm calling the unaggravated section. The blue section is what I'm calling the aggravated section. And the purple section is the penalty. And I want to touch on all of these three sections in sort of different, because they all raise different issues for me. And so the first one I'll talk about is the aggravated offenses. And from our office's perspective, the aggravated offenses are not necessary. We did a review of case law, and we called all of the longest serving public defenders in the state. I picked out 5 of them, which combined have about 150 years of public defense experience. And my question was essentially, can you think of a case, the 2 questions, can you think of a case where someone committed a murder and got off on a technicality? And the answer was no. Nobody could think of a case. There was cases where people said, oh, here's a case where there's clearly been a murder committed and they never figured out who did it, unsolved murders. But in terms of cases where someone was charged and then was found not guilty for some reason that was, a legal technicality, nobody could think of a single case. And so when we think of these cases in the context of murders, we're already talking about people who are going to be charged with murder and probably will not be charged with the lesser offenses because that typically isn't how the prosecutors charge. The example was brought up of aggravated murder. That's the most serious charge in the state of Vermont. That carries a mandatory life without parole sentence. You can't be sentenced to anything less than life without parole if you're convicted of aggravated murder. A prosecutor would not typically charge lesser offenses under that. That doesn't mean they couldn't, and it doesn't mean that if they could not prove aggravated murder, that they couldn't go and charge the other offenses. It just means that that's not typically how things proceed. Typically, you proceed with the top line charge and go from there. Now, in terms of what other offenses there are available, there's actually a lot of charges that are available. So in any case where you are doing something to conceal evidence of any kind in order to evade prosecution or avoid detection, you can be charged with obstruction of justice, which is a 10-year felony in and of itself. The issue is also brought up about what about other people being involved? If it's not, the person who commits the murder that is responsible for trying to hide or destroy or mutilate the corpse in order to avoid detection. And in those cases, you would also be charged with obstruction of justice and accessory after the fact. Accessory after the fact is actually, the penalty for that is you're punished as the principal. So if somebody commits a murder and then you assist them afterwards by helping them to conceal the body, you're charged with accessory after the fact, and the punishment for it is the same as the punishment for murder. So nobody could think of a case where anyone had evaded any sort of significant punishment for that was prohibited, for any conduct that was prohibited by the aggravated abuse section of this proposed bill. And we couldn't actually think of a way that you would wind up sort of, not getting convicted of everything else, but getting convicted of that. We were trying to dream up factual scenarios where you would, and we couldn't really come up with it. So the other thing that came up with this that was really interesting to me, I didn't know this before we started doing this, is we already have a provision in, here I'll go to one for Title 18, Section 5211, on the unauthorized burial or removal of a dead body. And it's a 5-year felony, which seems like that might be an appropriate penalty, except that it turns out Vermont is one of the few states in the country that has very specific and very purposefully permissive laws on burying your own dead. In fact, the Vermont Department of Health has a website, which I put a screenshot of up there, all about how to care for your own dead. And people in Vermont are allowed to do everything, stuff that in other states they're not allowed to do at all. In Vermont, people can file their own death certificate for a relative who died. You don't have to have a doctor or a medical examiner or anything else. Just as an individual, if you have a relative who passes in your home, you can file a death certificate. You can then file, if you want to bury the body on your property, which a lot of people do in Vermont. I actually was talking, when this came up, I talked, one of the lawyers that I called who's a friend of mine, who has a farm in Vermont that goes back 5 generations. And they have a family burial plot on the farm that's been in use as recently as the 70s. And they have people in their family who intend to be buried there when they die. And so we're a very permissive state when it comes to that. We don't require any form of embalming before burial. Many states do. We don't require the services of a funeral director. Even other states that allow for private burials on your property still require the use of a funeral director. So Vermont's very permissive in that respect. The permitting process for transporting a corpse, preparing a corpse, and burying a corpse on private property is actually less of a permitting process than it takes to put a garden shed in your backyard. You don't actually have to seek approval from anybody or get anything approved. You just have to file a notice with the town. And that's really just so the town clerk's office knows where bodies are buried in the town. And that has a 5-year felony attached to failing to comply with the permitting process. And that actually was sort of disturbing from our perspective, that we're very permissive about allowing families to care for their own dead and to bury their own dead. But we have a very draconian penalty for failing to file a permit with the town hall, which isn't even like it's not even like a zoning permit where you have to go before a board and get something approved. It's just literally a piece of paper you have to print out off state website and hand over to your town clerk that says, on such and such a date at such and such a location, we will be transporting the body of my relative and burying it. So because of that, what we have proposed is to try to incorporate really a change to the existing law about permitting for private property burials and private transport of the deceased, and to try to incorporate into that what we think is the really valid concerns that were raised in this bill for the aggravating factors. And so what I've proposed here is to divide Title 18, Section 5211 into 2 provisions. The top provision is the felony. That's for the aggravated factors. So in this, I've tried to incorporate all of the same things that were in the proposed Title 41. And in fact, I think I even took it a little bit broader. I looked back at the definition of sexual assault that's used in Vermont statutes, and it implies that it's hard to picture how you could fit a sexual desecration of a corpse into the definition of sexual assault, which seems to only apply to a living person. And that's why I chose the word desecration, which I think incorporates not just sexual desecration, but any other form of desecration. And I put that in that top section as a 5-year felony, which is what the current penalty is for failure to comply with the permitting process. I created a second section, subsection B, which is a fine-only offense, which I think is more appropriate for people who just failed to comply with the permitting process. If you go back to the permitting process, it creates a 5-year penalty, 5-year felony, or even if you do the permitting right, but you just do it at the wrong time. So if your permit says you're going to do it on the 19th, but the 19th is rainy, and you decide to do it on the 20th, that's technically a 5-year felony. And so that's why our office's position was that shouldn't be a felony. It shouldn't even be a misdemeanor. It should be a fine-only offense. And it should be, completely removed from the aggravating factors section, because we're talking about two really different types of violations. One is a grieving family that's trying to care for their own dead and files a permit the wrong way. And the other is much more egregious, much more criminal, and we think should be treated as a felony. But we like the idea of putting it all into one statute, because otherwise you wind up with very duplicative statutes. And that's my last slide.
Any questions? I have some, but I'll defer. Yes.
Did you speak with Attorney Seaton as one of your 5?
No.
I'm curious if you if you reach out to him. There was a State v. Rodriguez murder trial in Wyndham County this last year in October. And I am pretty sure that the facts of that case were, they were really testing the GPS data of like where she was and all these things, but that they almost conceded that the body was in her car and that she had transported the body. So they were. So I'm just your point earlier that there wasn't any fact pattern where this sort of thing had come up. I don't know for a fact because I was kind of following it peripherally, but like I think there may have been a murder trial in Wyndham County that had this fact pattern.
But I think that was actually a case that we talked about.
Okay, yeah. So
I think in that case, there was a conviction for a much more serious offense than transporting a body unlawfully. There was a conviction for murder in that case.
Yes, she was.
And that's what I was looking at was, are there cases where somebody has essentially somehow gotten away with the murder, but could have been convicted of this aggravated penalty? And we didn't find any case where that had happened. That said, we still did in our proposed amendment include the aggravated factors in there, even though we don't believe they're necessary, because we literally have not been able to find a case where those aggravating factors were present, but somebody wasn't already convicted of a much more serious offense. So we don't think it's necessary, but we did incorporate it into our amendment because we agree it's not, this is criminal behavior. We think it's already punished, addressed under obstruction of justice, the accessory before the fact and accessory after the fact statutes. But to the extent that we need those aggravating factors addressed separately, we think that they should be in that same section about burial and transport of bodies, so that we're containing everything having to do with the burial and transport of bodies into one statute.
Angela.
Oh, no, Karen had her hand up.
Oh, I missed it.
Karen, you both dropped the ball on Karen.
I got Karen.
No, you were, reading the bill and Karen actually raised her hand.
Oh, well, you didn't get my attention, Karen.
No, she got mine and I.
All right, Karen and Angela did.
Goes to the vice.
Yeah. Karen and Angela did.
Thanks for this, and I appreciate the piece of like, if we're going to be looking at it, let's look at it holistically and see those pieces of it, so. Appreciate that. One of the differences that I noticed though in your proposal is using the word intentionally, whereas proposed in here is knowingly, and I'm wondering if you could speak to why you are proposing intentionally.
I think that our office has, just as a matter of policy, we really definitely think that we should be limiting the number of mens reas that appear in Vermont state law. We've, as a state, been pretty creative with our intent elements. In other states where they hew more closely to, like the model penal code, which just defines a handful of elements and says these are going to be the intent elements for all offenses. We prefer intentionally over knowingly. We think there's a lot of overlap between the two. We think it can be confusing for juries when you try to distinguish between intentionally and knowingly. And from our perspective, the issue here is people who are intentionally trying to conceal a crime. If somebody knowingly buries a body, but doesn't intend to conceal a crime, I can't quite imagine the circumstances of that, but I don't know, somebody who just doesn't know better and doesn't think about things that way, who's every year there's hunters during hunting season that will find human remains in the woods. If somebody found human remains in the woods and felt, oh, that seems inappropriate, I'm going to cover that up a bit. They would be knowingly burying a body, but they're not intentionally concealing the commission of a crime. They're just doing something they shouldn't do. If you find a dead body in the woods, you don't touch it and call somebody. I'm not even sure who you call, actually. And that's part of the reason why we want it to be a, intentional level of mens rea, is because frankly, these are situations, like we're coming up with factual situations that nobody that I talked to in our office when we were just brainstorming this had actually run into these situations. None of us have found a dead body. None of us have run into these circumstances. And so none of us actually knew what the right thing to do in that situation was. We debated about, do you call 911? No, it's not an emergency. You probably call the general number at the police office. Somebody else pointed out that there's instructions on the Department of Health website that say to call the medical examiner. It's not clear to many people what to do in these circumstances. And we want to make sure that we're not tripping people up and getting them caught up in a serious felony for something that's really an unintentional act.
Angela.
So my question is about the placement in, moving this into Title 18 rather than 13, and just wondering functionally, practically, as a newly stated crime, maybe, would it be found? Like, how would
Title 18 is full of crimes. We use basically, like, there's crimes all over Vermont statutes, but the ones that really come up for us, you got Title 13, which is your general crimes. You got Title 18, which is anything health related. That includes drugs, alcohol, anything like that. We got Title 23 for all our motor vehicle offenses. And then there's some random stuff scattered elsewhere, fish and wildlife. There's a bunch of stuff in Title 7. There's stuff scattered in other places, but we wouldn't see that as being in any way hidden. Title 18, if you look in like a criminal defense lawyer's bag, they usually are carrying a Title 18, a Title 23, and a Title 13.
okay?
Those are our criminal books.
Tom. And then Tom.
Again, the first.
Yeah, well, yeah, you had your hand up. first.
Two. I keep thinking about this, being able to do what you want with your own thing. And I could see it really potentially backfiring in the negotiation was, okay, well, you're going to file it. Because there's no standards when you handle your own corpse at home. There's no the hole's this dimension, it's in this, not this vault. This is how the funeral home is gonna do it if you're buried in the cemetery. If you do it at home, it could end up being a shallow grave. And people move or somebody else passes away, there's no record of it. A body is found, and that is gonna trigger a resource response that's gonna be very expensive. There are missing people all over the state of Vermont. And I don't care how you slice it or dice it. I mean, the medical examiner, if you call them, they're probably gonna call the police. And then it's gonna have a crime scene unit and all these other things they're collecting up. So that's just my thought on that. Of why you would be required to file something with the town clerk, because then they can go to the town clerk, say, do you have anybody that did anything at home? And they hear, oh yeah, that's the same place we're at. Okay.
And we're not suggesting getting rid of the permitting process at all. We're just suggesting that a 5-year felony for filing your permit up with the wrong date is too extreme. And that's why we changed it to a fine of $1,000. And to be fair, the committees that have looked at, is it appropriate to be burying bodies on private land and everything? Those were actually all updated in 2017. So those are very recently updated.
We apparently missed this one though. 5211.
They actually did update 5211.
Really?
Yeah, they changed the name of the permit when they were rewriting all the burial codes.
Green.
They changed the name of the permit. They changed a bunch of things. And so they did make amendments to 5211 during that time.
Once again, another committee dealt with criminal penalties without coming here.
That could be a penalty.
That is not allowed. We get to
Yeah, that could
decide
be a
on how long to
misdemeanor.
hold people.
Yeah, gonna hold my thoughts, I guess, on the permitting thing right now, but you surveyed 5 Vermont defenders, and they haven't seen it. Maybe there's another defender that has it, and it goes to my mind that it probably has happened somewhere, maybe not in Vermont, that somebody may have gotten off on the technicality on a murder and then the other charge. And it just goes through my mind that that hasn't happened in Vermont yet. And I would just, and I know it's hypothetical and, you know, maybe it will, maybe it won't. And I would just hate to see it happen in a year, 5, 50 years down the road, that somebody has to come back in and wonder why this is such a light penalty. You know, with the penalty having, because I guess the only way I can put it is to agree to disagree on what the penalty. And I understand where you're coming from, and but to agree to, for me anyway, to agree to disagree with what the penalty should be. And again, I would hate to have to put a family member again in that position. To have to come in at some point down the road and wonder why it's somebody is only getting or potentially getting kind of a slap on the wrist for doing something as heinous as what did happen.
Just to be clear, I mean, there's no slap on the wrist. The person that's charged in the offense that was described is charged with aggravated murder, which is the most serious charge in Vermont. There's no other charge in Vermont carries mandatory life without parole other than aggravated murder.
No, I mean, I don't mean that charge of being a slap on the wrist at all.
Right.
But potentially, some people would look at your language and think that's a very, you know, a stiff penalty. But I'm just going back to a family member looking at it.
And what I'm suggesting is, honestly, if prosecutors found people who were burying, and I've actually seen this, we've seen examples of this, of people who are concealing a corpse, they get charged with obstruction of justice, or they get charged with accessory after the fact, and they get punished either with a 10-year penalty, the same as was proposed in H41, or with something even more serious if they're charged as accessory, because there you get punished as the principal. So you would be punished for the murder if you were doing something to a corpse to conceal it following a murder, or destroy it. You'd be punished for murder. So I think that's, when I say that we don't feel that the aggravating charges are necessary, it's because we already have so many charges that address this conduct. They're already punished very seriously. They're punished as serious felonies, 10 years for obstruction of justice, but even greater if it's accessory after the fact for murder or accessory before the fact, or if it was planned at all between two people, then it's conspiracy.
So I guess is there, again, I think it's hypothetical and, what if, but the charges you're talking about that already have the higher penalties from the felony, could those maybe not come into play when it comes down to that this could?
I can't imagine a scenario where anyone could conceal a corpse for the purpose of conceal, bury, transport, mutilate, dismember, do anything to a corpse for the purpose of concealing a crime, avoiding apprehension, prosecution, or conviction of a crime without committing obstruction of justice, was just a 10-year felony. And it's the definition of obstruction of justice almost automatically includes all of those things because they are done with the intention of concealing a crime, avoiding conviction, apprehension, or prosecution.
Tom has the last very short question because we have to get to Kim.
I'm
We
just,
will be coming back to this again.
yeah, I know, I'm also thinking about this in a different way too. I mean, what had happened, science is good and we can often figure out what happened when and in what order, but we don't always know exactly the order, what everything happened and when the person died and when one act or another was committed. And that is a very aggravating set of circumstances to me if something had happened when this person was potentially still alive. Okay, and they're not paying for that. And they created this set of circumstances, this person. And the body's very sacred in many faiths, religions, personal beliefs, whatever, but for them to be robbed of the opportunity to have their mother there is important to me. And that was a different theft in amongst itself. That's what I'm saying.
It wasn't a question.
That wasn't a question.
No.
All right, I said
Yeah.
last question, not
Get it in.
because we're going to have plenty of time to discuss this bill. So since that wasn't a question, Angela, do you have a very short question
I
and do you
do.
have a very short answer?
Given what you just said, Marshall, that everything in that this is basically the definition of obstruction of justice, why wouldn't it carry the same penalty?
If we were to put this into place, right?
Yes, the proposed amendment.
That's a good question. I went with the 5-year felony because that was what was currently in Title 18 for failure to comply with the permitting process. And from my perspective, the important thing was this does seem to be serious, really bad conduct and should be punished as a felony. I prefer not to have mandatory minimums because I think that judges should really address cases on a case-by-case basis. And so I think that's the reasoning.
Appreciate it. Thank you very much for your testimony and we'll probably, we're going to be looking at this some more. There are some questions that I have about a couple of these things. Want some discussion and I think we do have to fix 5211 at a minimum along with this. So over to you, Kim McManus from the Department of State's Attorneys and Sheriffs. Identify yourself for the record and proceed, even though I just identified you.
Good morning, everyone. My name is Kim McManus. I'm with the Department of State's Attorneys and Sheriffs. Thank you for having us in. I know you only have a little bit of time and my comments are brief on the bill before you. simply, we understand the impetus for creating this felony charge for the behavior described in H41 and the gap that it intends to fill for the desecration of a corpse. From a very technical perspective, we just have two comments that we would like the committee to consider. One is, and this would be a question for legislative counsel, but I was not able to find corpse defined in our statutes. And I know the general definition is that it's of a dead body, and then usually the definition says especially of a human, but some definitions do say human or animal. And I believe there was a comment earlier by a representative of, what if somebody was trying to, sort of wedge in the destruction of an animal corpse. So just one comment, maybe for Ben to just double check, is whether or not the word human before corpse would be needed, or a definition of corpse. And there may very well be a definition. I just could not find it when I did a quick look. So that would just be one comment. The other comment is under the aggravated section where it says perpetrates or attempts to perpetrate sexual assault against the corpse. Sexual assault encompasses a number of different behaviors. And that, I think the term sexual assault could be a bit complicated for what I believe this bill is trying to address. And that would be somebody committing a sexual act or sexual conduct against a corpse. And so we would suggest, instead of the term sexual assault, inserting sexual act or sexual conduct. And those terms are clearly defined in our statutes.
So probably a cross-reference as well, presumably.
Exactly. And I know Ben knows those well, so I don't need to mention that here. And then just one note, as Attorney Paul was speaking about the penalty section, I was just double checking, and just for the committee to know, and you can check on your own time as well. Obstruction of justice, the penalty is up to 5 years. Accessory after the fact of a crime is a punishment up to 7 years. So it's when someone is involved before the crime or during the crime, is aiding in the commission of the crime, or is an accessory before the fact, that's when the person can be charged up to the principal of the crime, if that crime was murder, as Attorney Paul was saying, and be held to that high penalty. If it's after the fact, the penalty is up to 7 years. You're not charged as the principal. So I just wanted to note that, because in the current bill, the current suggested penalty is higher than that, a max of up to 10 years. So just wanted to point that out to the committee.
So I had two questions, and then I'm going to open up to other folks as well, but I just want to jump to these. Intentional and knowingly, is there any reason we shouldn't just say intentionally on both? Or do you like the distinction between the knowingly and intentionally?
I understand, and Ben described this earlier, the intentionally, what prosecutor has to show is that the person's conscious objective is to engage in that conduct. And it is nuanced, as everyone has said, and knowingly is that you are doing your action with knowledge and awareness. So there is a legal difference. It very much depends on the facts and circumstances of the case. Intentionally is seen as a higher mental state than knowingly, if you're putting them in order. So there's basically a little bit more has to be proven that this person intended to do that versus knowing what they were doing. And there's a slight difference, but so essentially it is a higher, the prosecutor has to show more of the person's mental state to prove intentionally versus knowingly. So that would be a policy decision for you all.
Okay, the other, if you could comment just on that's C2, the mandatory minimum. If the DSAS has a position on having the mandatory minimum.
We do not have a position on that. Again, that would be a policy decision of the legislature, whether they wanted to create a minimum.
Other questions? Okay.
So I think you were on when Marshall was speaking and sharing the thought that I apologize if I don't get this accurately, but that the aggravated section is not needed because that would count as obstruction of justice. I forget what the other one. Do you agree with that, or it seems like there's disagreement of if it's covered in current law or not? And so if you can speak to that, that'd be helpful.
Well, it is interesting. I think it would very much depend on the facts and circumstances of the case. And as I don't remember, I couldn't see who was speaking when they were saying, we don't know all the potential scenarios. And I do appreciate that Defender General were trying to think of all these various scenarios. I think one could for at least B1 and B2. So for the concealment of the crime in two different ways, either transporting or burying or mutilating, disfiguring, etc. Possibly you could charge obstruction. That is indeed possible. Again, the penalty is up to 5 years for obstruction of justice charge or accessory after the fact. What for number 3, B3, that appears to be a crime separate from the initial crime. So, again, like somebody could come upon, or not be involved, right, in the initial act of killing this person. And then if they were to perform a sexual act on this corpse, that's not obstruction of justice or accessory after the fact. So that would not be able to be charged. Thinking off the top of my head, B3 would not fall into what we already have.
Here.
I do have one other question, and the section about perpetrating or attempting to perpetrate sexual act or conduct, we can change to against a corpse. We don't have any law on the books against necrophilia now?
Not that I'm aware of, and I can go back and.
If you and we have legislative counsel here, I would very much like to just double check that, which would seem. Marshall, go ahead and identify yourself for record. And
Marshall Paul from the Defender General's office. There is a law in the book that prohibits sexual activity between people who are not permitted to marry, which I think would certainly apply in that circumstance.
I think we want to be a little more specific. That's the best we have.
I think it would probably apply.
It would, yeah. What's the penalty?
I don't actually know.
Anything. All right, so we will explore that a little bit. There's some other things to explore as well, Ben. Are there other questions for Kim? I don't see any right now, but we're going to be doing some further work on this, and we're going to have some discussion on this as well. But Michelle is on her way because I would like to vote out H27. She has the amendment. Actually, could you print out that amendment for us so everybody has it in front of them? That'd be great. Let me just throw out an idea of where this bill is and what I'm thinking of. And we're going to have further discussion, but I want to see if folks are kind of on board with maybe what we can do here. I think we definitely need to adjust 5211. I think this 5-year penalty is an awful lot if we're capturing really the criminal activities in this. I also kind of think it should stay in Title 13 or move to Title 13. I think it should be closer to our main criminal title. But I think also that means if we're doing that, I do think we need to work on, and this is page 1, line 19, the transports, barriers, or otherwise hides a corpse, because there will be kind of a overlap between 5211, which is transports or barriers without a permit. Do we really want just transports or barriers? Yeah, there's got to be something more there, is what I'm saying. So I think we need to look at that. We just heard about the sexual assault, probably should be sexual act or conduct with a cross reference to that. And we need to look at the definition of corpse. So I'm kind of giving Ben some things to look at. And one last thing I'm just going to flag, and then if there's anything else that we think Ben should look at for the next one. I'm very uncomfortable just generally with mandatory minimums, and maybe we're going to have Judge Zone in here just to reflect on how that may impinge on discretion of the court and being able to take factual circumstances. I'm not troubled by the maximum whatsoever, but anyway, yeah.
I just have a question regarding the potential to change 18 VSA 5211.
Yeah.
There's no mental state associated with that.
Right, which troubles me even more, that the
So
5-year
you
penalty.
could make the argument that it's almost a strict liability crime.
Right, and a 5-year penalty, and it's just if you don't have a permit.
So I just wanted to raise that. But
Yeah,
yeah, like it's already on the radar.
yeah, very much. I mean, Marshall did highlight how much we've done over the last few years on burying your own dead, and that seems to kind of potentially conflict with that push. Did I miss anything? Is that kind of enough to kind of keep this moving along?
One other thing I'll raise by our witness, I think it's raised by Attorney McManus, is that there's no definition of corpse. There is in 5211 in the Title 18 context. They don't use the term corpse, they use the term dead body of a person, which I don't think requires any definition. I think that's fine. And so that might address anybody's concerns about making sure it applies only to human.
Yeah, if we need to have that.
Corpse too.
Well,
Right,
Just dead body of a person.
It says
Right.
corpse, change it to dead body of a person.
yeah, if elsewhere, if Ben, if you could look elsewhere, there's an understanding that corpse might be somewhere defined, that could be an animal body or a human body. And if that's the case, then we definitely want to be specific here and say dead body of a person. But if you could just check on that.
Unless we change the definition. of
Unless we
corpse
change the
to
definition, yeah, right, or we could do
Yeah, right.
one way or the other, we need to.
Right.
So you're gonna mess up all.
Yeah, there was exactly, so we,
There's no
we,
thread you can pull.
yeah, we want, yeah, that's exactly right. We don't want to pull on threads and have the whole thing unravel. So Michelle is on the way over.
It's just interesting with something like this, the little nuances you don't expect, like definitions and the permit you're talking about with a, 5-year penalty for, us being off a day on a permit and just things like that are just, just.
So is there anything else that am I kind of reading the room and reading the testimony, at least to get to the next? I'm not committing anybody to anything, but I'm just trying to keep this moving up.
No, I think.
The necrophilia thing too.
And can we address that?
Yeah, so just to clarify sort of my marching orders, we don't really know what we're gonna do with Title 18 yet in that statute, right? That's still thought about.
I think if it's like a strict liability and it's just having a permit and we're capturing really the criminal conduct in here, it should be a fine only.
Okay, so do you want to roll that statute into H
No,
41?
I want to fix 5211, and I want that kind of separate, and I want to have this in Title 13.
But that would be in the.
Right, but I'm saying like the mechanism to do that.
Yeah,
You want
yeah,
to
yeah,
bring
yeah,
it into the
yeah,
bill
yes,
And then change it to a fine?
Yeah, I think so. I think I'm reading the room.
And you want to move it into Title 13?
No, just this is Title 13. The other thing
The other,
about
okay.
the no permit belongs where it is.
Okay.
Um,
And then define sexual act for conduct and then put that into language.
Yeah, instead of sexual assault, that's something we've been dealing with the last number of years.
Yeah.
And
And then exploring definition of a corpse, look to see if it's defined elsewhere, maybe insert dead body of a person in place, but still to be determined, and then explore the necrophilia statute.
You don't like just desecration instead of sexual act?
Desecration can mean more than just sexual act,
But, so it's broader.
right?
We don't prefer that?
Well, we're after something different here. Don't we have desecration in here? Dismembers, disfigures, mutilates.
don't.
So I get that sexual assault won't work because you have to have two living people. So to sexual act is more specific. If you want desecration, then it would be broader. So that could include, other things that aren't sexual in nature, but are also.
Well, I think, don't we have that covered in number 18? Yeah, all the burns, mutilates, disfigures, dismembers. I think we're after the sexual acts of conduct in
more specific. Okay.
B3, yeah, so.
But that's a policy decision that could change depending on.
Yeah.
Yeah.
Where you decide to go.
Yeah, all right, we good?
Just a question
Yeah,
about the
yeah.
knowingly, intentionally, or is that, let's save that
I don't
for another
think,
time.
we need to all discuss that one a
Yeah.
little bit further.
Yeah.
And maybe get a little more testimony. We can get Judge Zone to also talk to that as well.
Yeah, the MPC uses purposely. We have both,
The NPC is.
model penal code,
code.
but purposely and intentionally or essentially.
Maybe when we come back around to that, we'll get a little re-education and new education for some of our new members on the different standards of mens rea. So when we come back to this bill, we'll just use that as a way to do that. So Michelle, welcoming you to our chair to go over this amendment for H27. I am hoping that this is straightforward enough that we can vote on it, but we can see if people are ready. I will note that GovOps beat us. for the first bill.
No.
I thought you guys were gonna have this.
No, they beat us last biennium too.
No, H27.
No, yeah, right, no, I'm pretty sure.
Last session or last biennium?
Right.
Last year. First one of the biennium.
Okay.
I thought I did the first bill of I thought it was the,
Did you?
Thank you, Marcia.
Thank you, Marshall.
it was the, use of litigation.
Last year. Anyway, over to Allison, we can all get to lunch and then get trained on discrimination this afternoon.
Good morning. So for the record, Michelle Child's Office of Legislative Counsel, and we're taking a look at an amendment, a committee amendment to H27 relating to Domestic Violence Fatality Review Commission. I think Nate has provided a copy of that for everyone. We're looking at draft 1.1. And it's pretty straightforward amendment. So you'll recall one of the things that the underlying bill does is it expands the number of folks who are on the commission. So what you have here is you see on line 6, striking at 22 because you're going from 17 to 22 in the underlying bill, but you've added another person on there as well, and then also tweaked the language on the existing. So something that y'all discussed, I think, was you added the executive director of the Vermont Center for Crime Victim Services. So that is new. You had a state's attorney victim advocate on the bill as introduced. And I think when it kind of came over in the recommendations from the commission, it had the Center for Crime Victim Services doing the appointment. And then last year you switched that and we changed the language there and there was state's attorney. So that has been corrected there. I should have caught that. I apologize. I did not earlier. And so that victim advocate would be appointed by the executive director of the Department for State's Attorneys and Sheriffs. And then you have, which is not new, it's just that we kind of had to change the numbering and language there for the Director of Victim Services for DOC. So it's just really adding the executive director for the center and then fixing that little error there about who appoints the victim's advocate.
All right.
I'm happy to make a motion to accept the amendment.
Wow. Okay, well, do I have a motion? Do we have a second?
Second.
Are all further discussion about the amendment? Because then we're gonna have a vote on the bill as amended.
Yeah, I voiced my opinion on the size of it. On size, not just this board, but a lot of boards and commissions, but, and I don't remember who the woman was that gave a great explanation of why that they needed so many people. I may not 100% agree, but I can understand, what she's talking about and certainly support them.
Anyone
And
else?
it's one of the big reasons is that adding Jennifer Coleman on is big for me, so.
Definitely. Any other comment on that? All those in favor of the amendment, say aye.
Aye.
I don't think I need to have that part.
It's, it says my binder record of actions do not need to be. Or you don't need record of action for amendment.
Right, but I do need for the next motion, which I would take a motion to. What is the motion? How many times I've done this over the?
About 827 favorably?
Yes, that we've, 27 as amended favorably.
So moved.
Seconded.
Okay, any discussion on that motion? All right, so this one we're gonna call roll on. So we have that,
Can I ask a question?
please.
So you've already lost out being the first bill that's going to be voted on.
Right,
So is that coming back today?
which coming back?
Is that coming back today?
Zach,
Zach is not coming back.
So we've already lost out on this. So you wanna,
No,
The first-
we have other things. I mean, it's ready to go. There's no reason to hold up.
that wasn't my question.
What is your question?
My question was, we've already lost out on the first.
That doesn't
Get it out.
matter. I was kidding. about
Oh,
that.
I'm not sure.
That's-
So anyway, okay, so we'll vote. So you want to vote without a full house? Okay. Question answered. Thank you. I'm good.
So if this was what I thought was a close vote, because I kind of feel that everybody seems to mostly be on board. If it was gonna be like a close vote, I would postpone to make sure that everybody's here. But there are gonna be times when everybody's not here and doesn't seem to be a controversial bill and business must continue on.
No, you're just thinking differently than what I am, and that's fine.
Yeah, right. So any other discussion?
I'll quickly add, I just say that I'm happy to implement this recommendation and certainly future recommendations of this very important commission.
Yes, I appreciate that. No, I appreciate that. So if the clerk could call the roll.
Just looking at this, aren't you guys the last ones to be asked usually?
Yeah, it's Coach, then Tom and me.
Last, right?
Right, yeah.
Okay. We gotta fix this.
All right, well, that's be fine for now.
Arsenal,
Yes.
Dolan,
Yes.
Brunel,
Yes.
me, yes, Goldstein, I guess I gotta say. Harvey is absent. Malay,
Yes.
did I pronounce that right?
Mhm.
Oliver,
yes.
Rachelson,
Yes.
Christie,
Yes.
Burdick,
Yes.
Lalonde,
Yes.
Lalonde.
So I'm really sad that we
10-01.
don't have Joe Andriano, so we could just enjoy you mispronouncing it on
He's listening.
I think I got better towards the end.
Yeah, yeah.
You're fast, you're
But
fast.
you got Malay right off the bat, and I'm kind of a little disappointed. Sorry. So who would like to report this bill? Any takers? Anyone?
I will.
Yeah.
But two very enthusiastic.
I mean,
Enthusiastic babies. So excellent, Barbara. I appreciate that. I really appreciate it. So you know the process and
Let's see. Okay, so I need to, well, it's changed a little, right? And not since last year, but electronically, I need to send it to Nigel.
the final, you need to get the final, this is the final one that you sent. You'll get the final version from Nate emailed to you, and then you send it to Nigel and tell him it was 10-01 and you're the reporter and this is the amendment.
Okay.
Right? I got it, right?
Sounds good to me.
If you didn't,
And is there anything different because it's amended? Right, like once in a while, there's a quirky, like
No.
nuance,
Well, all we do is we send them the, that's all that's gonna go into.
which is in the final that you
into
sent
the-
us. You incorporated the amendment into the final bill.
The bill you get will have. the
No,
amendment in
no,
it,
so,
right?
the House calendar will just have the amendment. And you will have to
Okay.
refer the people to, out there to look at
Yes.
the whole bill.
It is not a
Not a
strike
committee,
all.
yeah, yeah.
Individual instance of amendment, right?
Yeah, okay,
So-
see, okay, rusty.
We've
Mixing
typically
it up.
done strike all, but
You typically have,
just in
Is
the
that-
last
is-
few years.
Does that make it easier,
Convenience of-
or-
Well, one reason is.
When there's multiple changes,
Yeah.
you know, it depends, and different committees do it different ways. So, but judiciary committees tend to enjoy a strike all, but if you're only changing a few little things.
Yeah. so,
Yeah.
Mixing it up.
so we are getting back together at 1 over at the pavilion for discrimination training. But just let me give you a real quick. No, this is the wrong one. Do you have the agenda for next week? I just want to give folks a quick, it's not foreshadowing, preview of what we're gonna be looking at next week. So Tuesday afternoon, we have the governor's budget address. We're gonna hear all about all the money he's gonna put into the criminal justice system. And 2:30, we have sorry, Ken, we're gonna have the oversight hearing on driving while intoxicated laws or driving under the influence laws. I'm not sure what the preference is there. On Wednesday, we're going to take up the after-hours access to orders against sexual assault, Tom Oliver's and many others, Bill. And then I'm hoping that we will at 11:30 have Katie McGlynn in here to review secure residential recovery facilities, mainly Act 137 from last year, which was supposed to be a forensic facility, but it kind of got changed. It is kind of what we're providing as a forensic facility, because we've heard, I think, several times in the last 2 weeks, forensic facilities come up. So I think that we need to understand where we are with that. And in the afternoon, we're going to do H25, which is related to impaired driver rehabilitation program, kind of going with the theme of driving under the influence next week, largely with the exception of the after hours thing. And then on Thursday, H44, which is miscellaneous amendments to the laws governing impaired driving. And then currently there's really to be determined for Thursday afternoon, and I'm hoping, I just putting in on Friday a possible vote for H64, the after hours thing, and H25. So I think are relatively straightforward. I don't think they're going to be real controversial. So I think we can move to those, and maybe then to be determined, which I have open on Thursday afternoon. Maybe we'll come back to H41. Okay. All right, just a preview. Any questions on that or any input on that?
Exciting.
Exciting.
So
Exciting stuff.
it'll be this.
So our last thing before we adjourn is that it'll be on notice on Tuesday. It'll be on the floor on Wednesday. On Tuesday, a couple of us will work with you, even though it should be straightforward, just so you all understand how we try to proceed with these, is that the individual doing the report will provide us the report and we'll give input. We'll have the small group, we'll provide input, and then we'll kind of do a moot. We'll do a practice run where we'll try to come up with questions just to prepare the person for reporting to them. So, with that, we'll adjourn until 1 o'clock at the pavilion.